Hi, good afternoon, everyone. I am Jamon, the attorney from Tilleke Gibbins in Dispute Resolution Department.
Good morning, good afternoon. My name is Tongmee. I'm working in restructuring and value creation team at KPMG Deal Advisory. So we are pleased to have you all attend in this 1-hour session. We'll give you an idea of the objectives and benefits of the rehabilitation process in Thailand for both debtor and creditors. So when and why the company may need to consider rehabilitation as an option to restructure your debt. And today, we are delighted to have 3 speakers joining us for this discussion. The first speaker is Kun Alongkorn. So please, can you introduce yourselves?
Thank you, Kun Tongrat. Hi, my name is Alongkorn Tongmee, a senior associate in Dispute Resolution Group of Tilleke Gibbins.
Hi, my name is John Frangos. I'm also with our dispute resolution group at Tilleke Gibbins, and along with Alongkorn, John Morn, and others, we work in our contentious bankruptcy practice.
And hi, good afternoon, everyone. My name is Matt Crane. I'm a director at KPMG in Thailand, and I lead our restructuring and value creation practice. Thanks all for joining us this afternoon.
Okay, the presentation will cover these 3 topics. Firstly, restructuring trend in Thailand today. Secondly, introduction to the Thai rehabilitation process. Thirdly, key consideration for debtor and creditor. And finally, there will be a quick Q&A session, and the speaker will answer your question in this session. Since everyone is here, let's begin with restructuring trend in Thailand today.
To get started, let's first talk about the situation and restructuring trends in Thailand today. As we know that the business were hit by COVID-19 pandemic, which lockdown restriction from government that caused slowdown in many business activities. So Matt, would you mind to share us how the COVID pandemic impacted to Thai economy?
Sure, thanks, Kuntongrat. And look, for those of you joining a bit late, you can be forgiven for thinking this is an economic update. It certainly isn't, and we will be going into detail about the rehabilitation process. But we did think it was important just to set the scene in terms of why is rehabilitation a topic today. And look, I think many of you on the call will have seen this chart of the GDP of Thailand. Unsurprisingly, like many economies around the world, the Thai economy has been severely hit by COVID, and that led to a negative 6.1% GDP in 2020. Interestingly, in 2019, we could already see that there were some economic signs of distress. Again, that was a global trend, not just here in Thailand. So what does that mean going forward? The current forecast from the Bank of Thailand is for a 0.7% GDP in 2021. But importantly, that's down from a previous forecast of 1.8%. So I think the conclusion there is that this third wave of COVID has really led to a prolonged recovery and a delayed recovery for the Thai economy. But there are positive signs, and the hope is that there will be a return to 3.9% GDP in 2022. But obviously, we'll have to see how the next 6 to 12 months pan out. If we could go to the next slide, please. So just going one level deeper into 2 key economic factors that indicate the Thai economy. The first on the left there is the number of tourists that we're seeing in Thailand. And then on the right, we have the level of exports from Thailand. And I think it's worth pointing out here that in the early days and months of the pandemic, Thailand actually controlled the pandemic quite well. Cases were relatively low. But that was clearly at a cost to tourism. So the number of tourists actually dropped off a cliff overnight and still hasn't anywhere near recovered to the 2019 levels of just under 40 million tourists in that year. And then if we turn to the level of exports, Interesting trends there where immediately after the COVID pandemic hit in 2020, we saw a sharp decline in exports as many of the primary purchasing countries, maybe our US counterparts or in Europe, really struggled to contain the lockdown. So whilst things were operating and continuing to some extent okay here in Thailand, those purchasers, those buyers were not putting the orders into Thailand. However, if we look into 2020, we can see that really picked up, and into 2021, we're actually above 2019 export levels. And there's two primary things driving that. One is that renewed relaxation, recovery in those economies that I've talked about, but also the strengthening of the Thai baht has really helped the Thai economy. So there's many businesses out there now, many of our clients who are actually seeing a significant rise in that export level. So what's the conclusion here? Obviously, the Thai economy has been severely impacted, and we're still struggling to recover from that, but there are positive signs. Exports we're already seeing up above 2019 levels. And even on the tourist side, you can see that very small red line at the bottom of the graph. Tourist numbers up to 18,000, 15,000 in July and August. And obviously with the recent announcement from the government that as of next week, we will be opening our borders to vaccinated tourists from low-risk countries. Hopefully that number will continue to increase. If we could go to the next slide, please. So what does that then mean for the level of debt that corporates are experiencing in Thailand? And here we've got a graph depicting the level of outstanding NPLs, which is non-performing loans in Thailand. And what we can see is that actually since Q3 2020, the percentage of NPLs as a percentage of total outstanding loans has actually declined slightly and been kept relatively under control. That's largely due to some support measures from the Bank of Thailand that's allowed some softening of those provisioning rules. But I think what's more important here is that underlying level of debt and underlying level of NPLs is still increasing. And we do anticipate that as relaxation or as support measures get turned off or relaxed, that level of NPLs could well go up as the economy starts to return to normal and some of the financial institutions, banks start to reclassify those loans and push for some of those repayments. If we could go to the next slide, please. So now bringing that to today's topic about rehabilitation. So we've seen the trends in the Thai economy, we've seen the devastating impact that COVID-19 has had, but the green shoots of positivity, of recovery. But interestingly here, we've plotted a graph of the number of rehabilitation cases that have been accepted by the court from 2019 through to Q2 2021. And what you can see is before COVID, very few cases. 2019, there were 7 cases in total. COVID hit, and then we can see in Q2 2020, Q3 2020, that number of applications or number of cases accepted did increase. And we've had a total number of 18 cases in 2020. However, I think many of us thought that that would continue to rise and there would be more cases put forward to the court and accepted. But look, that's not really come through as of yet. We can see in Q1 21, again, there was a bit of a spike with 8 cases accepted by the court, but Q2, again, it's fallen off. And I think there's 2 things that we would conclude here from this. One, I think many of those cases in 2020 were perhaps of businesses who maybe were already struggling a little bit prior to COVID, and the impact of COVID then gave them that extra incentive or need to apply to rehabilitation. And then we've had the support measures from the banks and the Bank of Thailand, who have been very supportive with a number of relief packages, which has allowed many debtors and creditors to decide that there's not a need to pursue a rehabilitation. And the third area, which maybe we hope to address today, is that we do still believe there's a lack of maybe understanding and education about the rehabilitation process and when it should be considered as an option. Now, that's not to say it's the only option or by any means the best option, but we do think some debtors and creditors are still unsure whether this is the right choice for them or not. And perhaps we'll see more cases into 2022 as some of that understanding starts to flow through.
All right, thank you, Khun Matt. So as we understand that there are positive signs which are expected in the higher number of tourists from upcoming reopen the country and higher export value from economic recovery in many countries around the world. However, the number of NPL is remain impossible to raise from higher level of new soft loan, which is currently supported by many financial institutions. So as we know that many companies have bank support which extend term of debt repayment, and some may not truly understand the process of the rehabilitation. So we would like to give you an idea of the introduction to the Thai rehabilitation in the next section. So, Khun Matt, what are the objectives and benefits that both debtor and creditors will have from going through the rehabilitation process, and what are the challenges that they may face?
Sure, thanks, Khun Thongrat. So look, I think people will have heard a lot about the rehabilitation process and maybe have their own perceptions about what it is and what it isn't. And look, we're going to try and cover today as much detail as we can. But I just wanted to start with a very high level of overview of why do people really go into rehabilitation, or why do they consider it? So let's start with the debtor's perspective. Primarily, they will be looking to keep the business operational. There may be a risk that if they don't enter rehabilitation, they may have to cease operations, potentially shut down the business. So that's one of the primary benefits and objectives. Also being able to keep their employees employed as well. One of the key objectives, and one that's often talked about, and I know the Tilleke and Gibbins team will talk about this later, is the protection from the automatic stay. So that does allow debtors protection from legal action from creditors that may be being taken. And then the last point we have here is that it allows the debtors time to formally restructure and negotiate their debts. So look, those are by no means exhaustive, but some of the key objectives and benefits from a debtor's side. If we look at it from a creditor's side, I think key reasons that a creditor might be looking to encourage their debtor to go into rehab would be to ensure fair treatment of all creditors. That is a primary objective and purpose of the rehabilitation process, to ensure that at least creditors within the appropriate classes are treated fairly. But ultimately also to ensure that they receive a repayment that is greater than if the business was to go into bankruptcy or liquidation. So a couple of key objectives, benefits there. I think if I just summarize that together, for me, the primary objective, and whilst it's not always successful, is to ensure that a company can continue operations for the benefit of all stakeholders, whether that be the shareholders of the business, their customers, their suppliers, their employers, but also the creditors. The objective of the rehabilitation process is to ensure that all of those parties ideally get the best outcome, because the business can continue to operate and can repay its debts to the fullest extent it can within the market conditions and business conditions it faces. And finally, the point I would make is around time. A lot is said about the rehabilitation process and the length of time it can take. And look, it can be extensive and lengthy, and that is not always of benefit to all stakeholders. However, at least in that first planning stage, entering into the rehabilitation process will allow the debtors and the creditors time to consider their options and think about what the best solution is for them. If we could go to the next slide, please. So I mentioned earlier about the number of rehabilitation cases and maybe the fact that some businesses don't know when they should be considering rehabilitation. And it's a question we often get asked as advisors, should I go to rehab, should I not? So we just wanted to touch on some of the reasons that a business might consider entering into the rehabilitation process. There are a number of legal conditions for filing an application, which we have at the bottom of this slide, but I'll allow my Tilleke Gibbins peers to discuss that later. So a few things to call out here. If a business is unable to pay its current debts, now look, that alone is maybe not a reason to go into rehab, but that's certainly a reason why a business might consider entering into that process. And that doesn't just mean it's debts to creditors. That could mean it's payroll to employees or other payments to the tax authorities, for example. Any liability that is coming due, if they're not able to pay it, this could be a viable option for that business. And not only the current debts, but the forecast debts. Is there a clear indication that the debtor will be unable to repay its future obligations? If so, this also could be a reason to consider. Often a reason is around seeking protection. So we mentioned the automatic stay already. If businesses are experiencing legal action from creditors, this is certainly an option to consider in order to get that protection and get some time to develop a proper plan. And the final point where we would typically advise our clients to at least consider a rehabilitation is where there are a number of complex stakeholders and creditors involved that all need to be managed effectively. That could be shareholders, it could be different debt holders, maybe bondholders, maybe financial institutions. Typically, if there are a number of different creditors and stakeholders that make it a more complex situation, again, entering into rehab can provide that structure and that time to develop a more robust plan. If we could go to the next slide, please, Kunjamon. Okay, so I think the last slide I'll talk about here is some of the challenges in the rehabilitation process. And again, by no means exhaustive, and the Tilleke Gibbins team will come on to some of the legal challenges later. But look, a couple of things to call out here. First of all, in the plan preparation, developing a robust but achievable plan to increase profitability and return to positive cash flow. Actually, that is often more difficult than it might sound, particularly given the uncertain environment that we're now living in. How do you make sure that the plan is robust but achievable? Because that will be reviewed and challenged by the courts and all the creditors. Secondly, and one of the most challenging areas is actually the negotiation with all the creditors. And it may not just be your creditors, it may be your other stakeholders, maybe your customers. You need to negotiate with them to make sure that they remain supportive and committed to the business. It may be some of your key suppliers who are concerned about the business. How do you make sure that they're on board with your future plan? So a lot of negotiation needs to happen. And that links to the third bullet point, which is around communication with stakeholders. This is so important. Regular, frequent communication, transparent as you can be around what's happening, what your plans are. Getting that buy-in is really important. And then once the plan is approved, if you've got through all of those challenges, then it's all about making sure the plan is delivered as it's been submitted. But I think we have to be honest here. In the current environment, it's very difficult to make sure that things go to plan. Particularly some of the plans that have been submitted in the last 6-12 months may well have changed due to the third wave of COVID-19. So what does that mean? That means there needs to be flexibility in the plan. And it also means you need to provide visibility and transparency to all of your stakeholders. Things will inevitably change. So it's important that you keep all those stakeholders up to date. So those are the key points from me. Maybe John, I know you'll talk a bit later about the details, but was there anything you wanted to add there on some of the key challenges?
Sure. Thanks, Matt. One of the points I'd like to make and emphasize what you brought up, and that's your third bullet point about communicating with stakeholders. And what I would say, and what we've seen from our experience working on these types of cases, stakeholders, and they include everybody from employees to business partners, shareholders, other types of creditors, they get very nervous when they see a company that they're working with becoming insolvent and looking to enter the bankruptcy court and seek protection. there's a lot of issues around that, including contractual triggers where a business partner or other stakeholder may be permitted to terminate a contract or undertake some other activity allowed by the contract when a party is insolvent. So communicating what's going on is critical and can save a lot of problems in the rehabilitation proceedings. Because if a stakeholder or creditor does not agree or is not on board, they could object and they could turn a proceeding into a contested proceeding. And that can make the whole process much more complex and time-consuming and expensive.
Thanks, John. Tongmee, over to you.
Yeah, thank you, Kun Matt and Kun John. As Matt said, there are many benefits to both debtor and creditor from rehabilitation under court order. Although rehabilitation is challenging, but I feel like if the debtor well prepared and have transparent communication with all stakeholders, they will be able to come up with the robust plan and be able to go through the rehabilitation process like successfully. Okay, so all of these are our basic business and commercial perspectives from KPMG. For our webinar, we also need you to understand legal will from Tilleke and Gibbins as well. So I would like to hand over to Kun Jamon for the legal perspective in the next section.
Thank you, Kun Tong. In session 3, the speaker, Kun John and Kun Alongkorn, will explain about the legal practice and the legal perspective on the issue of business rehabilitation. And we will start with Kun John. Kun John, could you explain about the introduction to Thai rehabilitation process?
Sure, thank you, Kun Jamorn. So I'm going to provide here just a very high-level overview of some of the basic requirements that a business has to meet in order to file for business rehabilitation, enter the Thai rehabilitation process. And we're talking here companies, not individuals. So first, most types of companies would be eligible for business rehabilitation by virtue of the fact that they're a private organization, a private limited company, or a public limited company. Also, the law, the ministerial regulations do provide for certain government agencies are also eligible for business rehabilitation. The second very important criteria is that the organization has to be insolvent or unable to pay their debts within a specified time. Now, it might sound obvious, but actually many would-be debtors who or rehabilitation petitioners, they look at their books, and while they're doing very poorly, they may not be insolvent. And while they may not be able to pay all their debts, they're able to pay some. That is not enough to meet the criteria for rehabilitation. The company has to be literally insolvent, where its debts exceed its assets. And on that point, the debt has to be at least 10 million baht, or put in the language of the law, not less than 10 million baht. So not a very significant amount, but still somewhat sizable. Next, another very important criteria is that the company has to have a reasonable cause to enter business rehabilitation and has to have prospects to succeed. That's not just an exercise in futility. By reasonable cause, we mean or the way the law would look at it is a company can't just have made a series of very poor business decisions that cause it to be insolvent. There must usually be some sort of external factor. We'll get into that in more detail in a few minutes. And prospects for success means that if the company does enter business rehabilitation, that it can have a fair chance to come out on the other side stronger organization, and it won't just collapse during the process. So these are very subjective standards, but a company has the burden to establish those. And then finally, the petition has to be filed in good faith. And what this means is that the petitioner cannot be seeking business rehabilitation just to escape its debts as a way to avoid the creditors without really intending to enter the rehabilitation process and benefit from the rehabilitation process, where it wants to continue the business and operate and then come out again after the process is over, a stronger company. And next slide, please. And with that, I'll turn it over to Kun Alongkorn to talk in a little bit more detail on these Thai Supreme Court cases dealing with these issues.
Thank you, Kun John. So, as Kun John said, the reasonable causes and prospect of success are key factors that the court would consider whether to approve the rehabilitation. We have a couple of examples which are the Thai Supreme Court precedent to share. This slide shows the case where the debtor's business, which is manufacture and sale of the steel product, is well structured and its products are very popular. The financial problem were not caused by the debtor's fault, but it was because the depreciation of Thai baht currency. Moreover, the major creditors, which are the banks, have supported the rehabilitation petition. The court considered that there were reasonable causes and prospect of success, so the court granted the rehabilitation in this case. Next slide, please. This slide discusses the case where the court concluded that there was no reasonable cause or prospect of success. In this case, the debtor has ceased its operation for 6 months already. When filing the rehabilitation petition, the debtor has inactive machinery and has no employee to operate it. The major creditor owning 80% of the total debt objected to the petition. All of these could not convince the court, so the court dismissed the petition. As you can see, as John said before, in order to succeed in the petition, the debtor should ensure that it talks to the major creditor and have them agree or support the petition. Otherwise, the chance of the success of the petition would be unlikely. Next slide, please. Back to you, Kun John.
Thank you, Kun Alongkorn. So here I'll go through very briefly the rehabilitation process, the legal process. So the first step, of course, is to file the rehabilitation petition. This can be filed by either a debtor or a creditor on behalf of a indebted party. So the court will look at the petition, consider whether it meets some basic requirements, and then decide whether or not to accept the petition. Now, this is a very important step because once the court accepts the petition for consideration, the automatic stay begins. And as we've already mentioned, and we'll mention again in more detail, the automatic stay is a critical component of the rehabilitation because it gives the debtors breathing room to operate their business and avoid creditors' claims and lawsuits. So during this point, the various creditors will be served the petition by the bankruptcy court, and will have a chance to then object. And this is why, as we mentioned a few times this afternoon, how important it is for the debtor to get the creditors on board, because if a creditor receives a petition and they don't like the fact that here's this party who's going into bankruptcy court asking for protection under the rehabilitation proceeding, they'll object. So creditors can challenge the rehabilitation petition, ask the court to reject that petition. The court will then hear from all parties, conduct an investigative hearing, listen to the petitioner, the debtor, listen to the creditors, and then make a decision as to whether or not to approve the rehabilitation petition. And then another very important point, appoint the plan preparer. If the court decides to approve the petition, now the debtor is officially in rehabilitation. And if the court decides to appoint the plan preparer, this part of the plan preparer could start preparing the rehabilitation plan. And as the name implies, the plan preparer is the party that literally prepares the rehabilitation plan but also takes over the management of the company, of the indebted company. So at this stage, creditors could submit debt repayment applications. So when creditors are owed money by the indebted party, creditors could file with another government official called the official receiver these deep debt repayment applications, saying this is how much we're owed, and this is what we need to receive, and then that will be resolved. At a later stage, a creditors meeting will be held to look at the plan and then vote on the plan. And if the creditors vote to approve the plan, the court will then consider and usually will approve the plan if the creditors have already approved it. And now once the court approves a rehabilitation plan, that's official. And then a new party called the plan administrator is appointed to take over the company and actually implement a plan. And this is where the business operates for a period of years, still under the protection of the automatic stay and under the rehabilitation plan, until ultimately the court may cancel the rehabilitation order when the rehabilitation is complete, or if the court views that the rehabilitation is impossible to continue. Next slide, please.
Okay, so automatic stay is not the word that expressly said in the law itself, but it's very important to the rehabilitation process. It is a measure which prevents creditor from enforcing debt repayment against a debtor asset and prevent creditor from filing a claim in relation to a debtor asset against the debtor. The automatic stay will become effective once the court accepts the rehabilitation petition for consideration. This can be very fast, which could be within 1 to 2 days after filing the petition. It happened before the court scheduled witness hearing to hear the petition, so it will be at the very beginning stage of the process. The automatic stay can end at several points of the process, such as when the court dismisses the petition or when the court cancels the rehabilitation. Next slide, please. Consequences of the automatic stay. Thai law provides 11 consequences, but we will discuss only some of the key effects, which are: first, creditor cannot file a civil action against the debtor in connection with the debtor assets. Second, creditors cannot execute or enforce the debtor asset except perishable property, such as fruit, vegetable, which the official receiver, if they think that the fruit and vegetable will be perishable soon, they can sell it by public auction and keep the proceeds to be distributed among the creditor later. Next is a property owner is prohibited from taking property back during the valid contract, such as a lease contract. The next one is very important for the creditor and the debtor under the process. The debtor cannot repay the debt, except in case that the repayment is necessary for the debtor business. For example, the debtor needs to buy a raw material for its manufacturing business, so that can be done. Next is the service provider cannot suspend public utility services such as electricity, water, and telephone. All of these prohibitions under the automatic stay can be exempted if the court approval is obtained. Next slide, please. Violation of the automatic stay. It is very important to note that debt repayment in violation of the automatic stay, meaning debt repayment without the court approval or which is not necessary for the debtor business, is void. Moreover, the debtor or any person who repay the debt in violation of the automatic stay would be subject to criminal liability for imprisonment up to 3 years and or a fine up to 300,000 baht. So if the debtor is not sure whether which debt it can repay, it is recommendable to obtain the court approval beforehand. Next slide, please. Back to you, John.
Thanks, Alongkorn. So here I'll talk about what can be considered reasonable causes for business rehabilitation. And these are very clear-cut examples, but I think are very good illustrations of what the court would consider to be reasonable causes. So the first example we have here is, let's say a company becomes insolvent because of a devalued currency, or we have here suspension of business due to a pandemic like COVID-19. We saw in the late 1990s the Asia financial crisis, which started with the Thai baht devaluing. As many people I think on this call may appreciate, the Thai baht can be a volatile currency. And so if the baht devalues, which causes significant debt, that would be a reasonable cause for business rehabilitation. And similarly, same thing with a lockdown or some other economic induced problem because of a pandemic like COVID-19. And on that same note, a natural disaster can also be considered a reasonable cause. For example, we have here the floods in Thailand back in 2011, where many businesses experienced significant disruption, which caused them to become insolvent. So these types of natural disasters can certainly be a reasonable cause for business rehabilitation. And finally, probably the most common reason is a recession in a particular business sector. Now, this can mean either in the global economy or the local economy, or even just a particular business sector where, for whatever reason, economic conditions have caused a company to be insolvent. So I think what the main takeaway here is as I've mentioned before, poor business planning or the poor business decisions by themselves are usually not considered to be a reasonable cause. And next slide, please.
Okay, so the debt repayment application is a very important concern for the creditor. Creditors who want to get repayment under the rehabilitation process must file a debt repayment application with the official receiver. The official receiver is a government agency who works for the legal execution department. The debt repayment application must be filed within 1 month from the date that the court order appointing the plan preparer is published in the government gazette. In case that the debt repayment application is objected by the debtor or other creditor, the official receiver would have to conduct an inquiry meeting or hearing and issue one of the following order: dismiss a debt repayment application, meaning rejected the application filed by the creditor, or approve full debt repayment, meaning whatever amount the creditor claim, the official receiver approve all of that, or approve partial debt repayment, meaning the creditor might ask for one amount, but the official receiver find that is not satisfied by the support or evidence, so then it can approve just only partial of that amount. Note that the amount that the official receiver approved on the debt repayment application will be for the purpose of voting at a creditor meeting, which will be conducted to consider and approve the plan, rehabilitation plan. The exact amount that the creditor will get repaid will depend on what the plan says. Next slide, please. Failure to apply for debt repayment. Creditor who fail to apply for debt repayment cannot attend the creditor meeting to consider the plan and cannot vote at that meeting. They also cannot receive the debt repayment unless the plan says otherwise, meaning that in some cases, even though the creditor do not submit the debt repayment application, but if the plan allows them to receive the debt repayment, they can receive the debt repayment. Next slide, please. So now we will go to talk about the legal challenges in the rehab process. The first one is a petitioner, which could be either debtor or creditor, must prove to satisfy the court that the debtor is insolvent, there are reasonable causes and prospect of success, like John said, and the petition is filed in good faith. The next is without good communication, creditor may object the petition. This can prolong the process that the court consider the petition, since the court may need to schedule additional hearing to hear the objection by the creditor. The other challenge would be the automatic stay, which is normally aimed to protect the debtor. So it normally affects the creditor right. For example, creditor who want to receive debt repayment during the automatic stay must ensure that the debt repayment is necessary for the debtor business, as I mentioned earlier, or must obtain the court approval. Next slide, please. Now we take a look at the prospect of success for the rehabilitation process, which is include the debtor obtain a loan for additional investment in the existing business. That means new investor might want to interest or might be interested in invest more in the creditor in the debtor business. Next, the debtor sell assets that are not essential to the business in order to obtain money for business operation. For example, the debtor sell the land that is not used in their current business to get more money for its operation. Next is when the creditor agree to extend the due date for debt repayment, or the debtor request and the creditor agree to reduce the debt amount or the principal. These all are prospects of success that the court would consider. Next slide, please. After the plan confirmation, after the creditor approves the plan, the court would also need to consider and approve the plan. The court will take a look whether there is any legal issue that the plan cannot be proceed, or the plan was prepared in bad faith, or is among the agreement between only a few creditor and the debtor. If the court approves the plan, the court will appoint the plan administrator. Then the administrator will be in charge of managing the debtor's business and assets. And as we discussed earlier, the period for implementing the plan would be 5 to 7 years. The court might agree to extend this 7 years again if the court consider that the rehabilitation is almost complete. Then if the business rehabilitation is successfully implemented according to the plan, the court will issue an order cancelling the rehabilitation. So that's all for the legal perspective. Back to you, Kun Chamor and Kun Torat.
Thank you, Kun Alongkorn and Kun John. That's about it for now. We cover. So I hope that all of you are clear on the business rehabilitation process. Kun Matt, do you have any recommendation based on your experience?
Thanks, Kun Jamon. Yes, lots of recommendations, but let me just maybe pick one to start with. And that would be to encourage both debtors and creditors to consider their options. Quite often, I will have clients call me saying, we need to go into rehabilitation, can you help us? Or a creditor calling me saying, we have a supplier or a debtor who we want to put into rehab. But I think I always encourage those clients to take a step back and consider their options. As we've hopefully demonstrated today, rehabilitation is a great option and definitely something that should be considered in the right situation. And sometimes I have those calls where someone's not considering rehabilitation and they could. So I think there's a real need for companies to step back, really look at their situation and understand what their options are, and whether rehab is the right option or whether there is another option. Because I think sometimes companies, creditors or debtors will maybe either only look at rehab or they'll only look at avoiding rehab, and they won't have a holistic view to consider both options as sensible alternatives. So yeah, look, that would be one key recommendation I would give to everyone. But maybe John, Kun Alongkorn, I'm sure you also have some recommendations you'd like to share with the audience.
Sure, I'm happy to speak next and share some recommendations based on our experience working on these cases. So one recommendation which really follows on what Matt just said is that when a company is considering rehabilitation, before it pulls the trigger. And it may sound obvious, but make sure that it is really insolvent and that it meets all the criteria under the law, and do a thorough analysis. So again, it sounds obvious, but many times companies are very tempted to just apply for rehabilitation to get that automatic stay protection without considering, do they really qualify for the business rehabilitation? And on that note, going back to what I said earlier about communicating with creditors, also very important, because when a creditor doesn't want the company to enter business rehabilitation, it can object. So I would emphasize that, because it's usually incumbent then for a debtor, when they're involved in the rehabilitation process, to make it clear that the alternative may be bankruptcy. And by bankruptcy, I mean winding down the company and selling off the assets. So I think that's something else that all debtors should consider. Thank you.
So for me, I think my recommendation would be that when either creditor or debtor would consider filing the rehabilitation, make sure that they engage the financial advisor and legal advisor to work closely beforehand, because not only the financial advisor can help with the insolvency or make sure that you have necessary proof about your financial problem, then the legal advisor will also can help you to make sure that all legal requirements are met.
Does anyone have further comments or recommendation? Okay, now I'd like to move on to a Q&A session. Over to you, Khun Tong.
Okay, let's move on to our last session, which is Q&A. So if you have any questions, please feel free to send us through the chat box on the right corner here. Actually, so right now we have questions for both of you, business and legal perspective. So what is the first step if you are considering to go through rehabilitation process? So maybe Matt, can you answer first?
Sure, yeah, I have my views on what the first step should be, and actually it may be different to John and Alongkorn's, but actually I would always start with the cash flow. So I won't apologize. Being an accountant, for me, it is all about the numbers. So if you are seriously considering going into rehabilitation, the first thing I would recommend is making sure you have a robust financial projection, and most importantly, cash flow projection. So how much cash do you think you can generate? How much debt are you supposed to be repaying, and what does that really look like? So look, and the reason I say that, it may sound again like an obvious step that someone would take before they even started thinking about rehabilitation, but again, it's often not the case. You know, particularly for the debtors, they haven't really got that robust forecast in place, so they really don't know, you know, whether rehab is required or not. So yeah, that would be my my response to that.
So then further from Matt's comment, I think maybe after the cash flow consideration, the debtor should also consider whether they can negotiate with the creditor, especially the major one. Because if they can talk to the major creditor, they may not even need to file the petition, because if they can get to the debt restructuring, then that would be more preferable.
Thank you for the answer. And we have another question from Kun Patirok. When business is considered to business rehabilitation, restructuring could be interpreted as insolvency.
Yeah, Matt, you go first, and I will add my comment.
Well, yeah, I think, to be honest, I guess I'll defer to you from a legal perspective, but look, I think that is a common misconception, actually, and look, as we've hopefully demonstrated today, the Thai rehabilitation process can be a little bit confusing, particularly for overseas creditors. So they often hear about rehabilitation and they think, oh, this company, this creditor's gone into insolvency. So it can be confused for it, but I guess my view would be that that's often a wrong interpretation. But can Alongkorn please feel free to correct me there from a legal perspective if you need to.
Yeah, thank you. I agree with Matt, but just for the legal requirement, the law say clearly that the debtor must have the debt over in debt more than at least 10 million baht. So it's clearly that the debtor must be in debt to one or more creditor. And then when the court will take a look at the insolvency, the court for the corporate debtor, the court will take a look at the financial statement. So then if you can show that you have the liability more than 10 million, so you might be eligible, but just you need to prove the other aspect as well.
Okay, so the next question is how rehab process help to maintain debtor operation. So maybe Matt, can you go first? Sure.
So look, I think we've probably outlined some of the key points there. One, it's that protection. So assets cannot be seized. Debts do not have to be repaid. So that does allow for the business to continue to operate. Machinery can't be seized, for example. So if there's machinery that's needed that maybe a creditor has collateral over, they cannot seize that. And as I said, the debts do not have to be repaid, at least in that planning process. So that can allow a company which is maybe facing the inability to pay its next debt repayment next month to continue for a few more months. And then I would say further beyond that, the whole idea of the plan, the rehabilitation process, is to develop a plan that allows a company to sustain its operations for the long term, and be able to survive. And often that does rely on renegotiating debts, potentially pushing those out for longer payment terms, or maybe debt equity swaps, for example, that just to put it simply, provides the company with additional cash flow in order to continue to pay for their operating expenses and generate revenue and positive cash flow.
Does anyone need to add for this question? So if no, may I move to the next question? Okay, I take it as a no. So the next question from Kun Chitchai. What do you think about making the shareholders the biggest creditors so that it is easier to control the process? So I feel like this is kind of legal aspect. So Kun Alongkorn or Kun John, would you like to answer this question?
Maybe I go first. It's possible that the shareholder can provide the investment or the money in the form of loan to the company, but in my experience, so that would be done. That should be done with the careful action, because the court or the other creditor might think that's something going on among the shareholder and the company that want to make the company go to the rehab in order to get the benefit from automatic stay. That I would share like this.
Yes, just to add to that point, the risk is what we discussed earlier about seeking business rehabilitation in bad faith. So if the shareholder is the main creditor and it's looked like it's sort of guiding the company into rehabilitation on the basis of that shareholder's loan and that alone, that could be challenged potentially by other creditors as being a bad faith attempt at rehabilitation. So it's doable, but care should certainly be taken.
Okay, so we have only a few minutes left, so may I have one last question? And if you have any more questions, you just ask the questions and we'll send you email later to answer every question you have. And the last question for today is how effective can rehabilitation be for a single asset hotel company with a single lender unwilling to restructure the loan where direct negotiations? Maybe Kun John, would you mind to share us your view?
Sure. So if I understand the question correctly, is how beneficial would rehabilitation be to a hotel, like a single asset hotel? Do I have that correct?
So how effective can rehabilitation be
sure.
asset hotel?
Potentially can be effective if all the conditions are met. Then rehabilitation can certainly be an effective way to continue to operate while stopping, in a sense, claims against that hotel. So it can be effective.
Maybe just to add, and Tongmee, if I understood the question, I think the addition to the question there was that there's one main creditor who's refusing to restructure the debt. Is that right? So I guess just to add my view, and John, chime in if you need to. Yeah, I think if there's one creditor that is unwilling to negotiate, ultimately, if you enter into rehab, depending on the other creditors or other stakeholders, that creditor is going to have the primary voting rights in the rehabilitation process. So whilst it will help, and there'll be some court support and oversight, I guess my view would be that if that creditor is not on board, it may not be as beneficial a process. But John, Alongkorn, I don't know if you have other perspectives on that.
Yeah, so thank you, Matt, for that clarification. If there's one creditor and that creditor is hostile to the rehabilitation process, then in that situation, unless, as Matt mentioned, the creditor does ultimately get on board, it may not be so effective, because then that creditor will not vote for the rehabilitation plan, or more likely just challenge the rehabilitation petition. And if that creditor is successful in challenging the petition and won't approve the plan, then the rehabilitation won't succeed. So in the situation described, rehabilitation would only be effective, in my view, if the agreement of the creditor can be obtained to buy in for the process.
Okay, thank you, all speakers. From this, I believe you can understand now the business rehabilitation is progressing. For now, that brings me to the end of our presentation. Thank you for sharing that time with us today. Goodbye.